Colleagues, this could be the final or at least the penultimate meeting of the Joint Select Committee. Depends on how we go on for the rest of the morning. We have 3 items to deal with. That is the data set from Dr. Warren Vernon, the objects clause, and also for Judith CPC to take us through clauses 5, 6, and the schedule. So I think, were there any apologies, Anila, for this one? I think Minister Favour Williams said she will be a bit late.
No, sir, I haven't received any apologies from members.
And we have a quorum to begin with. So I think we'll start with you, Warren. Would you like to go first, Warren? And then after that, Judith will deal with the other matters.
Okay, thank you, Chairman, and good morning, everyone. Okay, so some time ago, the committee members asked us to examine the data set and to indicate what would be required, and also to indicate the source document that would be required to verify, for example, someone's name. So looking at the spreadsheet on screen, the first item, 1.1, the full name, including any names used prior to change of name by deed poll or marriage. And our recommendation to the committee is that this ought to be required for ordinary residents and also for citizens. So our proposal is that this should be shall, and the source document to obtain this information would be birth certificate. You know, you can check also the deed poll or marriage certificate, etc., to find this information. This one, more than any other items on the list, would be straightforward. And the date of birth is something that you will be able to get from the birth certificate also. So a single document will be able to give us 1.2, and 1.3 is a country of birth. We can also get that from the birth certificate. And the place of birth is also required. That's our proposal. And 1.5, however, is going to be a challenge, especially in the Jamaican society, because we are aware that there are many persons out there where their father's names are not really on the birth certificate. And so our recommendation is that this is made where available. And so we're putting that to the committee. And I recall from the historical documents that we checked back in 2000, 2001, this was also a major issue then when that bill was being considered about whether or not it should be mandatory for father's name to be on the birth certificate. But the reality in the Jamaican environment is that there are many persons out there where the father's name are not on the birth certificate. So our recommendation is that it should be made.
Okay.
1.6, there were presentations, a few presentations concerning 1.6, whether or not, we should indicate whether or not male or female should be required. Our recommendation is that this ought to be required, and this is something that you can get from your birth certificate. The challenge, however, in the Jamaican context is that our constitution only recognizes male or female. So we can't get around that. So our recommendation to the committee is to consider the requirement for male or female at the point of registration, or what is on your birth certificate. The next big issue I would love to have some discussion on is the principal place of residence. The reality is that when you go to a bank now, they're asking you for utility bills to verify your address. But there are many Jamaicans out there that really don't have utility bills. They can't produce one. So our recommendation for consideration by the committee is for persons without a utility bill to verify their address. We are proposing that an address declaration form, which is to be gazetted and to be a statutory declaration form. And this form can be signed by, similar to what is on the passport application form. I think it's on the section 3, where you have a number of persons on that list. You have member of parliament, justice of the peace, you have attorney at law, and so on, that could sign this form. And it is important for persons who don't have utility bills, for them to be able to declare their address and for us not to leave anyone behind. Also, it is important for us to make provisions in regulations for even persons that are considered homeless and on the street, for them to be able to use a frequently visited place as their address, so that we don't leave anyone behind. So for this particular one, Chairman, I'm not sure if you'd want to get some comments from the committee members before I continue.
Well, first of all, the suggestions that you have put forward, I mean, it seems to me, apart from the principal place of residence, what you would want a sort of declaration from notary public, GP, or such other person who can be relied on to indicate that the person's address is as he says it is. Is that what you're asking?
Yes, Chairman.
Because otherwise, you know, there's no definitive way you're going to know what the person's address is. So,
yes, Chairman.
members of the committee, and the views,
Chairman, I think it's going to become burdensome, quite frankly. I understand what Warren is saying, but it's not easy for everybody, for the numbers that you're talking about, to get a JP to confirm that. I think it's an additional layer which, quite frankly, may just discourage enrollment. And I don't know how much it will really add to authenticating a genuine address. I tried to think through what else you could use, but you know, to go and ask everybody to get a JP to confirm it, I just think.
You see, Dr. Burke, my experience with the electoral list suggests that the vast majority of Jamaicans, or shouldn't the vast majority, but a fair percentage of Jamaicans are nomadic. They move regularly. Many of them rent places. Many of them move from the rural areas to the urban area. I think, in a sense, we will just have to accept the address that is given by the individual. I don't know, because even if a GP certifies that the person lives at such and such address, which to my mind is a bit challenging.
Because the GP don't know, the GP not going to really know.
Exactly, it's very difficult. So the other, you see, in a matter of a week or two, the person might leave that rental property and move to another property. So the address of the person, you know, will vary significantly. So I would say that we will have to rely on the person giving some indication, or you will just have to accept that the person says that he lives at this address. I don't know what other members think.
I mean, let me ask the question. I know, for obviously for planning purposes, you want to get accuracy in terms of where people live. But what is the mischief that someone would gain from giving an incorrect address? I understand in the electoral sense, because you do it because you want numbers in a particular marginal seat. But for enrollment here, I'm just trying to think through what would I gain by giving you a different address from my normal address?
Well, a simple real life example here, Mr. Robbins, is that someone may very well, you know, decide to give an incorrect address, go to courts, take out furniture. Courts maybe use the national ID to verify that person identity. And when it is time to repossess, they can't find the person at that address.
Trust me, courts find them people. Don't worry about courts. All of these agencies find where the people are.
But what we are also,
Warren, I don't want to make it too difficult for people to know. And I believe going to a JP, and there is nothing in that process that, and Minister Chuck said it about, and there's no disrespect to JPs, that won't give you anything that can authenticate whether it is really the address. You have genuine JPs who only sign for people who them know, but you have plenty of them who just sign. So,
but the other issue is that persons legitimately change their address quite frequently. Persons who are renting, for example, they might go on a 2-year contract or a 1 year or a 3-year contract, and at the end of the day, they move to another. They're probably earning more, they can upgrade a little bit, or their family has gone up. So address is going to be something that will change
almost annually.
Yes, and legitimately, not because they're trying to avoid courts or anybody. That especially for younger people, that is quite common.
So I don't think identity, the address, Dr. Vernon, is going to be unique. So we really have to admit and accept that an address given, you know, if it varies from the one that is on the card where the person lives, that it's going to necessarily be a breach, if I might put it that way. Because within that 5 to 10 year period that the person has a card, the likelihood is that that person, especially a younger person, would have changed the address 3-4 times, especially if the person is a student coming from the rural areas. They might come in and they might live on campus, and before you know it, they're in another boarded home, and then almost annually, wherever they can rent or board, that's will be their new address for the term or for the year in an institution. So you see, Dr. Vernon, I don't think you can use a given address as necessarily one that will remain with that person for any period of time. So what would happen is that each time each time the card is changed, they probably will give you the address at the time that that card is issued. But to ask for that address to be authenticated, I think it would be a challenge, a major challenge. So what's your result?
So Chairman, when we did our consultation, you know, you're right. The feedback that we got, there are persons who change their address even weekly. However, when we...
No, those are people trying to avoid them baby mother.
So if you look at on my screen, we would have looked at the passport application form and look at the long list of possible persons who could also certify or also, you know, could maybe sign to verify that, yes, this person is living at the address. So maybe a member of parliament, justice of the peace, attorney at law, bank manager, principal, pastor, and so on. So we were just presenting these for consideration because the challenge that we are going to have, especially for KYC and trying to help persons without utility bills to gain access to the financial system where they need to have an address that is verified. There's an additional layer that we may have to consider similar to the EOJs. How can we leverage that process even for needs to verify address? Because you're not going to be able to trust that address any at all if it is not verified. So it's something to be considered by the committee.
Well, I don't have a difficulty, you know, you say that the address provided and the application, that you would just have one of those persons you mentioned sort of indicated, but I just think it is something that will pose a lot of problems because, you know, especially in the inner city communities, you know, to get someone to verify that they live in a particular yard. I mean, how do you do that, Warren? in the inner city communities, you have big yard where, you know, the person lives. And oftentimes they give it as an address, you know, and as far as they're concerned, it is big yard on Grand Spend Avenue. You know, sure enough, who is going to challenge that, you know? So I'm not denying that address is important, but I can see for them to get anyone to verify that they live in a particular location is going to be a challenge. I think you literally have to put on the application that the person, the address giver, is verily believed to be correct by the applicant. You see the point I'm making? Because
Chairman.
yes.
So let's consider why it's important to have an address stated. And ultimately, it's to enable someone else to locate you. I mean, separated apart from, you know, your housing needs, is to enable someone to locate you in the event of liability, primarily. So in the court system, a person having a fixed place of abode is critical for the consideration of bail, so that the person can be located. For contract purposes, for purchasing items, if it is that the NIDS, once persons opt in and go through the process of enrollment and verification, life becomes easier. And verifying, having an address as a correct place, notwithstanding all of the challenges that we face, you know, with non-specific addresses, with people moving, I would lean towards a process during the verification stage that would allow for verification of the ID, because one way or another, for persons who require, whose identity has to be established, the address is always a critical part of it, not only for banking, but banking is a primary example of it. So it's at what stage is the work done? For me, really is what it comes down to.
But you see, AG, the concern that we have the next person, I don't know if you heard Member Robinson Bunting, that you, at the time of the application, the person may have an address A, but within a month, to use a parent, he or she may well move to address B. And therefore, you know, even when they do any interaction or transaction after a month, and they see address B, he gives address B, but the NID say, we have address A. Is that to say that the bank or any institution is said, but you acted falsely, you gave a wrong address?
But Chairman, let's be practical and realistic.
Yeah.
I mean, people will change addresses for any of many reasons.
Exactly.
Yes, but that doesn't mean that at a given point in time you were not at a particular address. So,
No.
But the same would be true of a driver's license that is issued with a stated address for someone who has moved since then and has not taken the step to update it. The same would be true for the voter ID, even though that has other implications, because the voter registration system ties you to a particular place, which is linked to a polling division, to an electoral division, and to a constituency. So that is a little unique. But the same argument that is being presented is true for any of the many other forms of identification on which an address is stated.
But all we're suggesting, AG, that to require the applicant to give some authentication by a minister of religion, a GP, an attorney at law, a police officer, is in our view a bit burdensome, unnecessarily burdensome. I think in a sense we have at an initial stage to just accept that the address that he has given is acceptable. Because
well, Chairman, here is it. The burden is going to be at somewhere, sometime, someplace, you know.
yeah.
Because if anything that requires proof of address, you have to go through a process of verifying it, whether it's presenting the 3 utility bills to show consistency. Oh, I'm so sorry, my chime has come on.
Yeah. You see, AG, let me give you, using even my personal example. I have my daughters give my home as their address because, you know, it's easy for anything to be delivered at my home and they pick it up. But they are sure they're there regularly, maybe almost weekly. But that does
plus you want them to vote for you.
exactly. So the point is that they may live elsewhere. They're almost weekly. So the point is that.
But the fact is that they can be found there. They can be located there. Should anything arise, they can be traced through the use of that address. So whether they purchase something and it is to be delivered to them, it will get to them.
No, admit it.
Saying, you know.
So the point I'm making, AG, is that once they give that address, then if you're saying that at least the one at the application must be verified, and thereafter, you know, it's going to vary. So because the address they give at the time of application, I can tell you, Dr. Vernon, in 30 to 50% of the time, within 10 years, those addresses would have varied. And that is what, you know, people are finding out now with the electoral list. That is why for jury service, when police go to visit these places to find these people for jury service, 80 or more % of these people cannot be found at the address that is on the voters list. So, you know, the address is something which is going to be very tough, Dr. Vernon, to get it as a unique part of the identification.
So Chairman, respectfully though, I think we're arguing 2 separate things. My understanding is that there are 2 sets of data to be captured. One is what can be changed, and the other is what is considered up to this point as uniquely unique to the person, if I may tautologiously put it that way, right? So even with, you know, nationalities may change because there's a process by which persons obtain and denounce nationality. Addresses may change. Even the designation of gender may change in this time, given everything that is happening. And so the fact that change may come to something doesn't mean that you shouldn't verify it at the stage of enrollment. If it is that for persons who are opting in, once you go through that process, life becomes a little easier for you to transact when you are required to establish your identity. That's my point. I'm not going to argue it any further.
All right. I think, Dr. Vernon, we better leave this to regulations to see at what basis we can get the applicant to give some indication supported by some authentication as to the address. Okay, but I don't think it should be it should be mandatory, if you put it that way, that they must give a certification by a GP, Minister of Religion. What is required is some indication of the accuracy of the address that was given, whether the applicant provides a driver's license, a utility bill, or some indication supporting the address. Would that be okay, Dr. Vernon? We will say that there should be some supporting indication of the address that is given or being put forward by, without making it mandatory that it must be from, you know, one of these authorities, so that if they can show that they have a driver's license with that address, or they have a utility bill with that address, or, you know, yes, if they can get someone in authority who can be trusted to say that is the address. So in the application form, it can be seen, when the address is put, it can be put something to say supported by what? You get me?
Chair, if I may, I'm picking up a little difference in understanding from what Mr. Vernon was, Dr. Vernon was. I believe what he was saying was in the absence of those documents, the applicant would be required to sign a statutory declaration that is their address before a JP, not that the JP or notary public would be verifying that it's their address. They'd only be, it would only be that the person would have sworn before them that this is my address.
So the question I asked you then, Kamika, why can't a person swear at the time of registration that this is my address?
Yes, Chair, that is what would take place, right?
No, but why? So in other words, what they're doing when they apply, they're going to sign by declaring that all the information provided on the application is correct.
Okay, so you're saying don't use a double.
Why? Yeah,
okay.
exactly. So everything that he has provided. Now, I'm not denying that in terms of the name, date of birth, and so on, they will have to be verified. Okay, but I don't believe that to go further and say that the address must be verified by a sworn declaration to a GP or a minister of religion should be added to the burden of the applicant.
Okay.
So what I'm really saying, Dr. Vernon, is that he's going to give you an address, and at application, the person will be sworn to say that this is the address that he is at the time of application. Now, to say that he must go and get a documentary evidence before a GP or a minister of religion to say, I duly declare that this is my correct address. I'm not too sure that we need to put that on the applicant at all. So, because having sworn that all the information that he has given on the application form is to the best of his knowledge and belief correct, then I'm not denying you need to check the name, you need to check the date of birth and other verification. But and if you can get additional documents to check the address, fine. But I don't think you should be asking the applicant to go outside of that swearing on the application to necessarily deal with verification of address. I think we should just accept from the applicant who has sworn that that is his address as correct.
Chairman, what do you think, Chairman, in addition to what you mentioned, also to have a requirement for the enrollee to update the authority whenever there's a change of address? In many countries, whenever you change your address, you have to notify the authority. It would be good to get the committee's views on this matter.
I think that is something that you could provide as an option for them, but you could surely do it as an option to say that in the event of this, you change it, this address being changed, you duly notify the authority. But yes, what we're trying to avoid is imposing on an applicant, which may turn them off the system. You see the point? So that I do agree with you that there should be an indication to the applicant that indeed, if you fail to give the correct address, it may in fact affect your application, say, to a bank for a loan, as an example. So that you could say that if you give the wrong address and the bank needs to find information about you and find that you have given the wrong address, it is going to affect your consideration. Okay, so that yes, I agree with you that on the application you can indicate that they swear that is the address, but you also indicate that in the event that you change address, you should notify the authorities. Okay.
Thank you, Chairman.
All right. I don't think we can go much further than that, Warren.
Okay. Thank you, Chairman. So the period of residents in Jamaica would be something that you'd get from PICO. Based on our consultation with PICO, this is sometimes stamped in the passport. So we'd obtain that information from PICO to decide how long the person should stay. The marital status is something that we can also get from the marriage certificate. And the name of spouse, I recall Mr. Robinson mentioned yesterday that in the Jamaican context, you may very well have someone with more than one, but but for this particular case, I think from our side, the requirement is to indicate one.
The legal one.
Yes.
So that to the extent that a person who is not formally married, but their common law spouse has got an order that they have lived together for more than 7 years and get an order from the court that they're legally married, then in that case, the person, you could use that as a marital spouse.
Yes, yes.
Because we do recognize common law marriages after 7 years.
Yes.
Okay.
And occupation, we want to maintain the list, and that list would come from Jamaica standard occupational classification, which is something adopted from ILO.
So would that also include, Dr. Vernon, if say a person is an attorney at law or a doctor or an architect?
Yes.
Something you would put on the back or the front of the card?
Well, it wouldn't be on the card because we have limited space on it, but that information can be verified using the card.
All right. Members of the committee, I've been in discussion with Dr. Vernon if we could put, JP, because Justice of the Peace, they've all been asking for ID cards, and I'm saying there's no need to have an ID card. When we have the national ID, we could put on the back where it says status JP, or if it is possible on the front, John Brown JP. So there's no need for them to get an additional JP card. But many of them want a JP card. So Dr. Vernon is saying that that is something that he's looking into when the card is being put together. Okay, members of the members of the committee have been in discussion with Dr. Vernon on that. Okay, continue.
Under the biometric information, Chairman, facial image, really a picture of the face. And this would be a requirement for all categories. And what we are recommending, which would be reflected in the draft regulations, would be for a live photograph to be captured at the enrollment site. So while you're taking the fingerprint, if available, you will also capture a live photograph. And for minors, you would want to take a baby to the site, similar to what is happening at the passport office. You could take a photograph because the baby is attached to the parent. So, and for fingerprints, it is important for the committee to note that there are going to be some Jamaicans or some applicants without fingerprints and some without hands. And in the regulations, the supervisor should be empowered to exempt those persons. So even though fingerprint is a requirement, there are going to be cases where you're not going to be able to capture it.
Dr. Vernon, wasn't for that reason why the proposal was for the alternate of the toe print?
When you look at the reality, because toe prints, when you look globally, toe prints is usually used for minors, for babies.
No, well, I understand. So I don't know whether they have the same effect as the fingerprint in the absence of finger. Whether it's used for minors is another matter. And I thought, my understanding was that you can get to the same uniqueness from a toe print as you do from a fingerprint.
Well, you see, when you look at the reality on the ground and to put the enrollment officers to a situation like that where you have them taking
practical considerations.
Yeah, taking the footprints of adults in our context. It can be.
Got you.
Yes. And then the manual signature is something that is also a requirement, but we also have to bear in mind that there are some persons who, again, won't be able to sign because they have no hands, and there are some persons who may not be able to read and write. So we also have to bear that in mind where regulations is concerned, that some person may just be able to just make an X alone. So it's important to note that.
Fine, yeah.
And the final category would be the reference numbers. And the reference numbers are important to just to ensure that the NIDS won't be allowing somebody to start all over again with a new identity. So you want to use a reference number to verify whatever documentation is presented to the authority to verify someone's identity. So take, for example, your driver's license. You'd want to capture that driver's license number and verify the document with the issuing authority to make sure that the document is a genuine document. The passport number, you want to capture that and verify it also during the vetting process. The national identification number, and what is being proposed is for us to issue all numbers from a central place to prevent duplication and so on. And the birth certificate number or your civil registration number, you'd want to capture that because, again, you're going to tie the enrollee profile back to the birth certificate so that when you have the registration of birth or change of name and so on, all of those can be managed and automatically be updated. There's also the proposal to maintain the part number so you can do the verification for persons that are on social programs to make sure that you don't have someone maybe getting the support multiple times. And there's also the EOJ card that can also be used as a reference point to verify someone's identity. And all of those are really the reference number just to verify so that when the vetting officers going through the vetting process to confirm the information provided, that they will be able to verify them through the corporation provision in the proposed bill. And those are the few points that I wanted to share.
Before you finish, Dr. Senator Hill, you wanted to ask an interview.
Just a quick reinforcement of what Dr. Vernon has said, the chairman, because it's important when that NIDS card is issued. I mean, it's going to be taken as we would say in Jamaica, as Bible, by a whole heap of people who will lend money, who will want to identify the person as a person who should be owning land. It is going to be a very, very vital document. So everything that goes into the building of that card and
when I say must be verified as best as possible, though, Senator Hill.
As long as you define as best as possible.
Well, the next,
because you either verify it or you're not verifying it.
No,
because if you have to decide, Chairman, what I'm saying is you have to decide which of those initial document or pieces of data or biometric that must absolutely be verified.
No,
because once you decide that and you decide that universe, whatever it is, those must be verified. Because anything outside of that will make the card and the NIDS much weaker than we intend.
No, but Senator Hill, there are certain items which are permanent. Certain items which are permanent. Your name, unless you do a deed poll, your date of birth, there are certain matters. But what we were discussing earlier is not permanent, and therefore you can rely on address given at any time as being necessarily permanent. In other words, so to the extent we argued at the time of application, when you give an address, we have argued and we don't want to go over it again. It may vary within a matter of a week or a month, certainly.
But Chairman, there is no, when the request is made for an address, it didn't say the address must be permanent forever. It says, give me an address as it exists today. And that's what you have.
Exactly. And so we did discuss earlier, I don't know if you were on.
Yeah, I was on, but when I asked for your biometric, I'm not asking for it, it's permanent today or today or for the next 20 years. We have decided that a biometric is going to be taken, and we decide at that time if it's permanent or not. So we should not be wasting our time with the permanence of an address, but we should be accepting that whatever address is given should be verified.
Right, I have no difficulty. No, but what I'm trying to say though, Senator Hill, and this is where we had the discussion. Surely the applicant who was sworn to it, to say that the NIDS team should do like the Electoral Commission and go and verify that address, that would be almost impossible.
Yeah, I agree. So you defined verification. That's all I'm saying to you. If you decide that the officiating NIDS officer at the time with a witness is the constitute the verification process, that's it. But just have it verified and define how it's verified and move on.
Okay. I mean, as I said, that is something that is a work in progress.
I wasn't talking so much about the address, but I was talking about the other parts of it.
No. Well, all the other
and
things.
I support those.
Wonderful. All right, Dr. Vernon, unless there are any other questions to Dr. Vernon, we are going to move on. And Judith will have time probably to take us through clauses 5 and 6 that we had not completed. And after clauses 5 and 6, we are going to go through the 4 schedules, 1, 2, 3, 4, and 4. That we can start, but the likelihood is that we may not finish. But before we finish, I had circulated a proposed objects clause that the CPC had sent me yesterday. And to that extent, if we accept it, then basically we would have replaced clause 3 with what is being proposed by the CPC. So CPC, are you ready? You want to take us through, well, it's really clause 3, 5, and 6. CPC?
Yes, Chairman, thank you.
So we see how far we get after we finish 3, 5, and 6. Then we will then do some of the schedules, and if necessary, complete it tomorrow morning. Okay? All right. So
right.
You want to do the objects clause then. By the way, colleagues, an email was circulated. So you could look at your email yesterday at about 5 o'clock with all of the changes on that the bill itself, but the one we're concentrating on now will be clauses 3, 5, and 6. So go ahead, CPC.
Thank you, Chairman. Good morning, everyone. Starting with clause 3, the proposal is to replace the existing clause with a more general provision dealing with the objects in keeping with what was proposed yesterday. And
so just read that, what you have.
Right. The objects of this act are to provide for A, a system of national identification, and B, a system of civil registration in conformity with all laws applicable to the protection of identity information and other personal data, as that term is defined by the Data Protection Act.
So colleagues, what is being proposed by CPC, rather than having those, what is present in clause 3 from A to H, she thinks that this proposal capture everything that is there. And my other concern, CPC, do we have to could we put personal data, define it in the interpretation clause and say, and put the definition of it as provided in the Data Protection Act? Why I'm saying so, when you say as the term is defined by the Data Protection Act, then the person has to go find the Data Protection Act to see what is the definition.
Well, that would be usual, Chair, because if we're tying it to that definition, we don't want to reproduce it here because then if there's any change in the provision in the Data Protection Act, it would necessitate an amendment to this act.
Oh, I see.
Necessarily practicable.
So you're saying that the possibilities that that term may be redefined by the Data Protection Act at any time?
Yes. Yes, Chairman.
All right, so colleagues, what's your, if we come back to this because this is new, and then we can go 5 and 6, and then we can have the discussion afterward. So go to 5 then, CPC.
Yes, Chair. So these changes, so clause 5 are in keeping with what was presented by Ms. Facey as the changes proposed for the governance structure of the authority. So at 5.1, we've inserted wording to establish the authority as a commission. In subsection 3, the provision dealing with the functions of the authority, which enable it to develop policies, procedures, and protocols for the creation, management, and operation of the national identification system, has been broadened to specify in some more detail what this would entail. So it would include developing policies, procedures, and protocols dealing with the enrollment of eligible individuals, the assignment of the NIN, the issue of national identification cards, collation and reproduction of information obtained as required under this act. Of identity information and the promotion and the use of the national identification number and national identification card, and ongoing research on developments and best practices in civil registration and identity information management.
So that, colleagues, clause 3 has been widened to cover a number of the proposals put forward during the discussions. All right, and it is there, which CPC has provided and read. So that's
an additional paragraph H has been added to include as the functions the monitoring of the authority's operations to ensure that they are in conformity with the Data Protection Act, the Financial Administration and Audit Act, and all applicable financial instructions issued by the Financial Secretary under that Act, the Public Bodies Management and Accountability Act, and any other law relevant to the management of public bodies or the protection of identity information.
Okay.
So that's the additional provision there.
And then
And a new 4 has been added as well to enlarge on the functions of the authority and specified in more detail the responsibility for developing the strategic direction of the authority and the policies in support thereof. And it sets out in detail what that would include. Things like reviewing, evaluating and approving the corporate policies, operational, strategic, and corporate plans, annual budgets, reviewing and evaluating the financial statements and major expenditure proposals of the authority, keeping the minister and the permanent secretary informed of all matters relating to the administration and management of the authority, giving to the executive director directions in respect of the management of the authority and to operate in a manner that maximizes the effective and efficient operation of the authority. Also, to approve the annual, quarterly, and other reports of the authority required to be submitted on.
Chairman, I have a query.
Sure, go ahead.
Ms. Grant, maybe you're coming to it, but I haven't seen it. I thought it would be upfront. Would the authority not also have the responsibility to evaluate the performance of the executive director?
Is there a G?
I skipped it. G. Can you go? Oh, it was coming.
Performance
of the authority inspector. No. Require the executive such periodic reports. No.
Here as part of the functions, Senator, but when we get to the schedule, which deals with the appointment, terms and conditions of employment of the executive director, it's set out in more detail there.
It is set out there that the authority will will evaluate the performance of the executive director.
Yes.
Stated.
Yes, we'll see.
If it's not, can you make a note, please, because it should have that specific responsibility. Thank you. Go ahead, Chairman. Thanks.
Go ahead.
Right. So here, the authority, as part of its functions, would monitor the performance of the authority in respect of its performance targets and service standards, and require the executive director to provide it with such periodic reports and such special reports as the authority considers appropriate in respect of the management of the authority.
So, what Senator Hill was saying, at 4A, review, evaluate, approve, and monitor the implementation by the executive authority. Is it possible for the authority for you to put review, evaluate, approve, evaluate
the performance of the executive director? The executive director must be accountable to a body for his or her performance. And the authority should do.
What I was explaining is that is set out in the schedule. So when we come to the schedule, when we deal with
and I accepted it enough.
Dealing with the performance of the director, if it's not set out.
I accepted it, Ms. Grant.
Like
it's your chairman who stop you. I'm okay.
Okay, no problem. When we get there, we'll check on it. All right.
That's right.
Okay, so that's it.
A new subsection 5 and 6 dealing with just the power to delegate functions of the authority to the director or any member of staff or member of the authority. So those are the new provisions dealing with the authority. The new provision now dealing with the executive director, which would replace the board of management. So clause 6, we have deleted what was there before pertaining to the board of management, and
everything in clause 6 has been deleted.
Right. So
clause 6 introduced.
Right. Clause 6 sets out the functions of the executive director and then provides for the provisions of the first schedule to have effect with respect to the appointment terms and conditions of employment of the director. So if we would like now to go to the schedule, we can see those provisions.
So the new schedule is totally revamped, or is it a correction?
Yes, it's a well, parts 1 and 2. Part 3 would remain mostly as is. So it's a revamp of what was formerly part 1 and 2.
Mm-hmm.
And in fact, we've now dispensed with the parts, so it's just one complete schedule which would deal with the composition of the authority as well as the appointment of the director and staff and all the other matters pertaining to the constitution of the authority. So paragraph 1 provides for the authority to be composed of the following members as appointed by the Governor General by instrument of the broad seal, acting on the advice of the Prime Minister, given after consultation with the leader of the opposition, and provides for membership to include an attorney at law, and some direction is needed here in terms of the specific qualifications for the appointment of that attorney at law. We had agreed on 15 years standing, I believe, but is it desirable to have a requirement that that person be a member of the Bar of Jamaica or of any particular region? Perhaps the committee would like to decide.
He should be a member of the Jamaican Bar.
Yes.
Or she.
You have it in bracket
Yes, so we can just confirm the provision for the requirement for the person to be a member of the Jamaican Bar.
No, definitely. Just being a member of the Jamaican Bar.
And frankly, no other bar. That's fine.
No, I agree. In other words, if they're a member of another bar, they must apply to become a member of the Jamaican.
Thank you very much.
Right.
Thank you.
Right. Also to include a representative from the Jamaica umbrella group of churches from a list of at least 2 nominees submitted to the Prime Minister by that group. An individual who has demonstrated knowledge and experience in information and communication technology and cybersecurity. And you all.
Mr. Chairman, I want us to just stop there, pause for a minute. I noticed that we have a time frame for the lawyer. And clearly, a lawyer who has just left law school is quite different from a lawyer who has been practicing very intensely for 10 or 15 or 20 years.
Right.
It is the same with an individual who must demonstrate knowledge and experience in IT and cybersecurity. I really believe you should have a minimum time that the person has spent in the field in that expertise. And I believe something less than 7 years should not be acceptable. But that's my view. It might be, somebody might say 5, somebody might say 10. I think 7 would be a good place because you really do need that experience. You're going into a world where really and truly cyber criminality is just a part of your daily work.
So what has been suggested by Senator Hill, which I will give some support, is that for C, D, and E, we should put who have demonstrated, knowledge and so on for at least 7 years or 10 years. I mean, other members, do you have any?
I think 10 years are fine.
Colleagues, any support or objection to that proposal? I support it.
I'm supporting it.
I make one adjustment, Chairman. I'm quite willing to go with 7 years for the IT person for the simple reason that you really want somebody with new knowledge. And I think 7 years experience will still bring a measure of new knowledge. When you go to 10 or 15 years, you're probably getting dated knowledge.
But
the other ones you can go for 10 years if you want, but I think cyber at 7 is a good one.
Let's be consistent. Let's just say 7 years for those 3.
Yeah, Senator Hill, I really think when it comes to cybersecurity, it's diminishing returns the longer the years of experience. I don't know if we should set because it's usually the young kids who are on the cutting edge of technology issues. So I don't know why we would want to.
There's a reason why, Senator Bunting, and I appreciate what you're saying. The experienced person will know which bright kids to hire, but the bright kids won't know the issues of policy that will be involved in a position like this. So I think a 7-year period is a good time. They still are in the business, and if you go to look at the senior people in the security business, which is really where the cutting edge is, they have some years under them, but they really do know where to go to hire the young smart kids.
So Senator Bunting, they're not necessarily the ones doing the IT work.
We're looking at the board.
We're looking at the board.
But Chairman, before we leave this, I just wanted to make a comment.
Sure.
If whoever is
recording
managing the screen
stopped.
could just go back to the top of this clause.
Yes.
Where the following members, the authority shall be composed of the following members appointed by the Governor General acting on the advice of the Prime Minister. The way this is constructed, we may as well make it appointed by the Prime Minister. Why don't we make it appointed by the Governor General after consultation with the Prime Minister and the leader of the opposition?
No, actually.
How it is constructed here, in reality means appointed by the Prime Minister. So we may as well put it that way.
No, no, that is correct, Senator Mountain. CPC, let's use the phrase as we use in the various commissions appointed by the Governor General after consultation with the Prime Minister and the Leader of the Opposition.
No, Mr. Chairman. No, Mr. Chairman.
No,
Mr. Chairman.
Senator Hill.
This was discussed in detail, and you were there.
Yes.
And the issue is that when you're in the final analysis, the government is going to be responsible to the people of Jamaica for this, and the Prime Minister will be obliged to consult with the Leader of the Opposition. But the Leader of the Opposition can't get a veto in this. It cannot be. So
who's talking about the veto? Who's talking about?
I listened to you. I didn't interrupt you. So I don't believe. Very often we go about trying to water down the authority of elected people in our country. We have a Governor General. The Governor General can push it back and say, look, consider again. But in the final analysis, if there's an impasse, the right person who must change that impasse is a person who got the leadership position from the people of Jamaica. And I stand very strongly on that. And I think the way it's written is the right way for it to be written.
And I support you, Senator Hill, fully.
Look, I'm not saying that it shouldn't be the Prime Minister who has the authority. I'm saying if that's what we want, then we may as well just say that. They will be appointed by the Prime Minister, maybe after consultation with the Leader of the Opposition. But I don't, this convoluted way of bringing the Governor General in when, it's really the Governor General is only a post box in the process. I just don't see the value of it, quite frankly, because in reality, it's the Prime Minister who is appointing the members. So if that's what we want, then let's just say that.
No,
Member Bunting, you're old enough to remember Gigi Ferzel Gospel, and many GGs have had very private but firm conversations with prime ministers. And I think, Chairman, how this is written is good for Jamaica in the system that we now have in Jamaica.
I agree on that comment too, Senator Hill.
All right, so all right, let's what I don't remember, is this what is used in all the commissions of Parliament, CPC, or the phrase no? I know this is the phrase that is in the Constitution of Jamaica, but is this the same phrase that is used in the appointment of commissions of Parliament, CPC?
I'd have to check, Chair, and get back.
Use the one in the Constitution.
Yeah, all right. We're we innovate in governance as we go along. The Electoral Commission of Jamaica, for example, is an innovation that had no precedent in the Constitution. Our governance arrangements can be frozen at the 1962 understanding of what our Constitution and what our democracy was.
This is a term used for the EOJ.
No, it's not. It's not.
Yes.
No, the EOJ, the Prime Minister, there are different members. There are independent members who are selected by the Governor General, and there are nominated members who are nominated by the Prime Minister and the Leader of the Opposition. So if you don't have knowledge of it, stop. Please don't interrupt those of us who are very familiar with it. I served on the ECJ for 7 years. So this is not the construct that is used for the ECJ. Now, all I'm saying is we don't have to slavishly follow a 1962 in large part constitution, but our governance arrangements must evolve. And I just think as constructed now, if we want to say it's the Prime Minister who appoints, then just say so. We don't have to go through this.
And clearly, I disagree with you, so which is my right. So it's on the table.
Any other member, Senator Sinclair made his comments. Any other members have any comments? AG, are you with us?
Chair,
Yes, go ahead.
I am in agreement with Senator Hill. I don't see anything wrong with the way the clause is phrased. I really don't see the difficulty. And I think the Governor General should also be a part of the process. If the Governor General is of the view that he's seeing something from a perspective and wish to have word with the Prime Minister, he should be involved in the process in this way.
Well, you're in the middle there, Mr. Simmons. AG, are you on?
Prime Minister, I was just about to ask that that intervention be repeated. I didn't hear all of it.
No, what is happening, AG, is the phrase that is now used is there, that the phrase that is there, which Senator Hill is supporting, that is the phrase in the Constitution. Senator Bunton is saying we could use the phrase that I believe is in the commissions of Parliament, that Governor General consult with the Prime Minister and the Leader of the Opposition. There's a slight variation in it, to the best of my knowledge, in the relation to the commission.
It was used with one commission, and Chairman, you were in the meeting when the Prime Minister gave his view on that.
Okay, no, I understand, but at least we can get the views of the other members. So we're supporting you, Senator Hill, but I just want other members to indicate.
Mr. Chairman, this is obviously at the end of the day going to be a policy decision. If the government wants it to be a particular way, it will be. All I'm saying is a simpler construct and a more pragmatic, realistic construct is saying either we want the Prime Minister to have the power to appoint, and let us just give it to him. If we want the Governor General to have the power, then let us give it to him. But let's not. The way this construct is, it pretends that it's the Governor General who has the authority when it's really the Prime Minister. And I have much more current examples of this of how this has worked. And it is, in this construct here, it is the Prime Minister who decides, and consultation is simply a letter of advice to the Leader of the Opposition.
So, Chairman, may I just indicate that constitutionally, the Governor General is mandated to act in accordance with the advice of the Cabinet or a minister acting under the general authority of the Cabinet in the exercise of his functions. That is a general position. So no head of state acts.
Right, no, but there is an exception.
Where is otherwise stated. And that is
when you, Attorney General, if you just allow me, when you weren't, may not have been paying attention earlier, I said, while that was the traditional construct, we have made exceptions. For example, in the Electoral Commission of Jamaica, where the independent members are selected by the Governor General in his own right. So all I'm saying is, in some areas, we have evolved beyond this particular wording, which was sort of the conventional wording. If I think certain appointments, maybe the DPP and other positions. But we have evolved in terms of the Electoral Commission, where we really want the Governor General to be the person selecting the independent members. And the nominated members are done independently by the Prime Minister and the Leader of the Opposition. No, all I'm saying is the reality of this wording here is that it's the Prime Minister who appoints the persons. That's the reality. I mean, going through, you have a process to go through, but the reality is the Prime Minister. So if we want to do that, and I'm not arguing the policy position, I'm just saying it would be much simpler to just say the Prime Minister can appoint after consultation with the Leader of the Opposition. It just seems to be unnecessary, sort of stylistic and just traditional wording to have to go through the Governor General.
So it's more than stylistic, though, Member Bunting. I appreciate what you're saying. If it were to be stated that the appointment would be done by the Governor General without more, then that appointment still would be an appointment that is in accordance with the advice of the cabinet, or in this case, the minister who has responsibility for
No, Attorney General, with respect, I use particularly the example of the Electoral Commission of Jamaica.
Yes, but you are interrupting.
Where the appointment of the independent members is without consultation with the cabinet.
Hold on. You are interrupting without hearing the full response. Once we are designating an appointment by the Governor General, it has to be done in accordance with the Constitution. And the Constitution provides for different variation. There is also a provision that where the Governor General may exercise his function in his own discretion. So that what I'm hearing you to say is that if it is that the Governor General is to make the appointment, we should opt for the version which says in his own discretion. Otherwise, however stated, it is going to be the Prime Minister, the Governor General, acting in accordance with the advice of the cabinet or a particular minister. So the general rule in respect of the exercise of the Governor General functions is that it is done in accordance with the advice of the cabinet or a minister acting under the general authority of the cabinet. And then the exceptions would be functions that is expressed, however you express, that is exercisable by him in accordance with the recommendation or the advice or the concurrence or after consultation with any person or authority. And for example, it could be with the Services Commission, it could be the Judicial Service Commission in respect of the appointment of judges. It could be on the advice of the Electoral Commission if we go that far, but you can designate whomever the advice or consultation can come from. The second limb is the function which is exercisable by him in his own discretion. And by way of convention, even when it is so stated and it becomes ultimately an exercise of the Governor General's discretion, there is consultation with government. So it's not necessarily farcical or sham to say that the appointment is done by the Governor General, because an appointment can be done by a Prime Minister, which does not have anything to do with the Governor General. But the Prime Minister cannot make an appointment on the broad seal.
Yeah,
if I may come in here.
The point here, I was just saying that because this has been a format, that's the traditional format, doesn't mean that we have to follow it, because there have been adaptations since independence, and we it's not, if we want to, I believe we can, because the precedent has been set. But I really don't. I know there's precious few minutes left in this sitting, so I'm not going to belabor the point.
Okay, all right. Thanks.
Good to hear, Chairman. And I think that's
the persons who are listening. Mr. Hill, don't mean to interrupt. I mean, it has to be understood that even where the Constitution provides for the exercise of the functions in consultation with, if that consultation does not yield a consensus, the power reverts to the head of government to make the recommendation.
And
so
it's a good place for me to
never be given that it is a sham to include a consultation with a Prime Minister, because a Prime Minister is a head of government regardless of who the holder of that office is.
It's at that point, Chairman, I'd like to take 30 seconds or so to just say this, that the issue brought by Member Bunting is a constitutional one and probably should be discussed elsewhere, but his point is taken. But the point about the consultation with the leader of the opposition and or the Governor General, the sham, it would be almost analogous to say, well, a joint select committee really is a sham because the government has the majority to push it through. No, it's not a sham. And really and truly, and I'm sure Member Bunting knows this, that very often prime ministers of either side have had discussions with leader of the opposition, and something has been brought up, and maybe not a particular nominee may have been put forward, but somewhat of a compromise that after a discussion is put forward. So it's very important that we keep that going, and that the bigger constitutional issue should probably be discussed elsewhere.
I understand that. The assumption, I believe, by the drafters of this original clause or the convention is that if the prime minister consulted with the leader of the opposition and he had a violent, disagreement on the nominee, that, the very construct of this would that it should be unlikely that the prime minister would then still go ahead with the appointment. That's the assumption. But, as we've seen, not just in Jamaica, but, around the world, that these sort of more civil, gentler approaches that may have been in vogue at the time, not all office holders take that approach,
Okay.
But as I said, I don't want to belabor the point.
All right, thanks, Senator Bunting, thanks, Senator Hill and AG. I think we're going to stop here, CPC. I was hoping we could finish, but there's no need to rush. I think we can take another half an hour to an hour tomorrow morning to complete looking at the 4 schedules. We will complete schedule 1 tomorrow morning, and then the other 3 schedules are fairly short. And then what I would like colleagues, and I will again circulate by email and WhatsApp, that anything to do with the draft report, that if you have any concerns with any part of the draft report, please let us know either by email, WhatsApp, or tomorrow morning we bring it up. Because we really want to sign off tomorrow once we have finished the 4 schedules on the draft, and also that we plan to attach this present bill with all the changes shown to the draft report so that Parliament can see what are the changes that were suggested, recommended in the bill. And we are hoping, my suggestion to the committee, which I hope you will adopt, is that we withdraw the present bill and then issue a new bill as it will look with all the corrections. So that one of the suggestions that we will put in the draft report, after we have attached this bill showing all the changes, is that this bill be withdrawn and a new bill, maybe 2021, be issued with, when we table the report, which I'm hoping will be next Tuesday. So we're hoping to sign off. Sorry.
Chairman, may I ask you not to conclude on that proposal? I would like to have a sidebar with you, and then we come back to the committee in respect of
tomorrow
that.
Morning, no problem. So we can come back tomorrow morning to make final decisions, okay? So we're going to conclude this morning, and then tomorrow morning we continue to complete and to make the various recommendations to complete. Okay, so thanks everyone for joining us this morning. And can I have a motion for adjournment? It's almost 10 o'clock, okay?
So moved.
I second.
All right, wonderful. Thanks everyone for joining us this morning.